Do you see this sick, vile person? The one that's standing next to his attorney. Well, he's not innocent, but he's definitely sick. He betrayed his daughter's trust. Let's sit back and see how this case unfolds. Make sure you subscribe and like this video.
On Zoom just because I knew she wouldn't be there.
And if we could remember, we use initials.
Yes, yeah.
All right, good luck. So this is in the matter of the people of the state of Michigan versus Jeffrey Lee Kapnick II. We have file number 24-21720FH. I have Michael Dagger-Margosian appearing on behalf of Mr. Kapnick, who is present in the courtroom. I have Phoebe McClure appearing on behalf of the people. This is the date and time set for sentencing. Mr. Dagger-Margosian, just for the record, you did receive a copy of the PSI along with the updated victim impact statement.
Correct.
All right, and Mr. Kapnick, have you had an opportunity to read and review the pre-sentence report?
Yes, no.
Okay, you guys can move that if you want. And you've had an opportunity to discuss that with Mr. Dagger-Margosian?
Yes, Your
All right, are you picking that up, Ms. Schwartz?
Yes.
Okay, Mr. Dagger-Margosian, or I'm sorry, are you satisfied with Mr. Dagger-Margosian as your attorney and the advice that he's given you?
Yes, Your Honor.
All right, Mr. Dagger-Margosian, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
Nothing in the body of the report, Your Honor.
All right, does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect? I show no prior record at all, including no juvenile.
Yeah, I have nothing to add.
The probation department has calculated the minimum sentencing guidelines on both counts to be 0 to 17 months. Do you, is it 0 to 17 or, yeah. Do you agree with that computation of guidelines?
Your Honor, I think I would like to challenge OV11. I didn't submit anything, but I think we could take care of it today.
Hold on, let me get it.
Yep.
So I'm going to my book. 4, 6. OV11 is criminal sexual penetration. It's scored at, let me see here. It's scored at 25 points for one criminal sexual penetration occurred. And okay, and Miss McClure, I'll let you get there.
Yep, I'm here.
And I do see that there was a transcript, so we can access that record as well. So hold on one second. Let me go back through the narrative of offense. All right, so there was an interview where the victim indicated that her father had forced her to perform oral sex on him and had penetrated her vagina with his finger. So I'm going to presume that was the score for that. So
well,
go ahead.
So for OV11, Your Honor, there needs to be a penetration additional to the sentencing offense, and it must arise out of the same course of conduct. In this matter, the date range of offenses are fairly unclear. I mean, the information lists it as 12/16/2020 through 2/15/2023. At the exam, the victim stated that there were 3 incidents, but that they occurred on separate dates, and that in my reading of the transcript, there was not a showing of an additional penetration, additional to the sentencing offense on each of these 3 convictions. So for that reason, I think it's improperly scored. It should be 0.
All right. So OV11 scores all sexual penetrations of the victim by the offender arising out of the sentencing offense. Criminal sexual penetrations of the victim of the sentencing offense, which did not occur during that offense, may be scored in OV12 or OV13 where appropriate, pursuant to the instructions for those variables. Points are not to be scored for the one penetration that forms the basis of a first degree or third degree criminal sexual conduct sentencing offense. Talks about rubbing of the vaginal area. Okay, so where the trial court scored OV11 on the theory that there were additional sexual penetrations of the victim by the defendant arising out of the sentencing offense, but the record does not establish when these non-charged sexual penetrations occurred. There is no evidence in the record supporting a finding that there were additional sexual penetrations arising out of the sentencing offense, and thus OV11 was erroneously scored. People v. Thompson, 474, Mish, 861, 2005. He pled to 2 counts of criminal sexual conduct, 4th degree. I'm sorry. So, Ms. McClure, are you able to respond at this time?
Yes, I do believe the record substantially supports scoring OV11. I would point to the exam transcript where the victim did testify to an additional oral penetration that was not a part of the original charges in this case, but it was, and that was only simply because we weren't exactly sure where that had happened, but it was around the same date as what was charged. And she did testify to that and testified pretty substantially as to that oral penetration. So in addition to what he was charged with, and then this obviously being a reduction, I think you could count any of those penetrations under the law or under the controlling law for OV11. But in addition, we had the one that she did testify to that was around the same time as these charged offenses.
Now, my pre-sentence report, Ms. McClure, states that the victim indicated that the assaults were always similar and always involved both vaginal penetration with his fingers and oral sex. She stated that this occurred more than 5 times and that the assaults would happen once or twice a day. Was that testimony taken from the preliminary exam transcript or?
It was, and I believe in addition to that statement, she also detailed at least 3 during the testimony.
Mr. Decker-Marcos, in response.
The statement of 1 to 2 times per day was not part of the exam transcript, at least when I read it this morning. I may have missed it, but I think that was not part of the transcript. I do agree with Ms. McClure of the, at the exam, the testimony of the 3 different incidents. But again, those were not part of the same concept. Those were all separate incidents. So that's my argument.
And I didn't review the transcript, Judge, but I did review my notes from the exam where at least my recollection was that she testified to 3 separate penetrative incidents. My note was, there would be another acts notice given the number of times she testified to. That's what I was relying on to say, yes, she did testify to happen multiple times over the course of or throughout this time period.
And I agree with that, just so to be clear.
Anything else? All right, so the felony information in this file indicates that during the time period of December 16th of 2020 through February 15th of 2023, that the defendant he's charged with first degree CSE, which is a life offense, and obviously it was pled down to the 2 offenses we're here for today, which are 4th degree. We do have preliminary exam transcript testimony from the victim that there were more than 3 at least digital or oral penetrations. Therefore, I believe that under People v. Thompson 474 Mish 861. There was evidence on the record to support a finding that there were additional sexual penetrations arising out of the sentencing offenses. I am going to leave OB 11 scored that way. So any other objections?
No, thank you.
Okay. So I will leave the guidelines scored at 0 to 17 on both counts. All right. Did you have any objections to the guidelines, Ms. McClure?
No, thank you.
All right. So before the court passes sentence, is there anything, Ms. McClure, you'd like to say on behalf of the people? I have read the victim impact statements.
Okay. So just to elaborate on that, and I know I've made this spiel kind of in front of you before, Judge, in these types of cases, and I know looking at what the charged offenses were and kind of the facts that were alleged here, and then looking at what the plea bargain charge was. I always like to mention at sentencing, there's a lot of reasons why these plea offers are taken. And I would just like the court to consider that I did consult with the victim and her mother in bargaining this plea. But in addition, I would like the court to consider her mental state at the time as we were approaching trial, how this affected her. And I think you can see through the victim impact statement that it did greatly affect her and has over the years. And I think it would have done more harm than good to have her testify at trial. She did testify at the preliminary exam, but again, that was a couple of years ago. So by the time we were approaching trial, I think it would have been somewhat of a setback. And I considered that in making this plea offer. I know the recommendation here is that he serve 1 year in the Lenawee County Jail with 8 days for credit. I just think given where we were at when this plea was taken and prior to the trial, I would ask the court to defer that jail sentence. I think that would be more appropriate given why we had to make this plea agreement. I know that's uncommon for me to ask, but I would just like the court to take that into consideration. I do think it's a fair recommendation, and typically in these cases it would be fair, but in this case I would just ask that maybe that be deferred and all other sentences as recommended would be imposed.
Well, I'm sure that just took the wind right out of your sails, Mr. Tuggermer goes in to ask for no upfront jail.
Your Honor, I did speak in length with Ms. McClure on this matter. I agree with what she stated. I'm not going to elaborate the point, but I will say that, we were prepared to move forward with trial. In speaking with Mr. Kapnick and in conducting the exam, as diplomatic as I can be, I was skeptical of the case. And so Mr. Kapnick didn't want to put his daughter through this again. And so for all those reasons, that's how we've landed with this agreement. So I guess I would just ask the court to follow the proposal by Ms. McClure of the suspended or deferred, however we want to label it, incarceration. This court has heard me make objections to provisions 4 and 5. I know where the court stands on that, so I'll just note that for the record. But other than that, Mr. Kapnick is, as the court saw in the PSI, there's no criminal history of any kind. He is working. He wants to move forward from this. So I'm asking the court to follow that the people's recommendation.
All right. Anything you'd like to say in your own behalf? I'm sorry, Ms. McClure, go ahead.
Okay, just a brief response. Just that I don't want the plea offer or the sentence here to reflect that I guess the state does not believe the victim in this case. And that's not what my position was at all. And I do hope that the defendant does take accountability for his actions and that at some point issues an apology to the victim and her mother in this case. Thank you.
Okay. Anything you want to say on your own behalf, Mr. Kapnick? All right, it is determining the appropriate sentence in this case. The court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication, prolonged protection of society. It is a sentence of the court that you will be placed on probation for a period of 5 years with the Michigan Department of Corrections. You are going to pay $750 in court costs, $130 crime victim rights fee, $136 in state costs. That's two combined there, $60 DNA fee, $30 per month supervision fee, and $60 per month if we have to put a tether on you. You are to remain active on the Michigan Sex Offender Registry for life. School safety zone restrictions will be ordered. You are to have no contact with the victim in this matter, directly or indirectly. You are to have no contact with children aged 17 years or younger. You must enter and complete sex offender treatment. I'm going to defer the 1 year in jail that I was going to order based on the recommendation of the prosecutor's office. And I will give you credit for 8 days, but understand if you violate probation, not only could you be looking at a year in jail, you could potentially be looking at up to 17 months in prison. Do you understand?
Yes.
Your attorney, and you should be grateful to your attorney. He worked out a very good deal for you. During the terms of probation, not to violate any criminal law of any unit of government. As I said, no contact with anyone under the age of 17, complete treatment. Now, your attorney objected, as he always timely does on these cases, to the restrictions that you can't reside, work, or loiter within a school safety zone, or defined as 1,000 feet of school property, developmental kindergarten through 12th grade. Unless you need an exemption, you're not to be within 500 feet of parks, municipal swimming pools, playgrounds, childcare centers, preschools, arcades, or other places primarily used by individuals age 17 or under. I am going to order those terms, but I do note that your attorney did make that objection. As I said, you're required to register. Make sure you're in compliance with that. Failure to do so could result in another felony. You are not to have any access to the internet using any device prior to completing and signing the MDOC Internet Use Agreement. You can't leave the state without the consent of this court, which you would get through your probation officer. You're not to use or possess alcohol, use any illegal controlled substances, and you are to test as required by the probation department. You must report monthly or as often as they require. And if you have police contact, move, or lose a job, you need to let them know right away. Failure to do so could result in a violation of probation. They also have the right to search your person, your property, your vehicle, your residence, your computer without the need of a warrant if they have reasonable cause to believe that you have items which violate the conditions of your probation. So, Mr. Jones, when do you want him to report?
Next Tuesday's fine.
What time?
Whenever works best for him.
Okay, so you need to report between 8 and 12 next Tuesday morning, all right? Now, my bailiff's going to hand down to you the notice of right to appellate review. You're going to initial and date the top copy for our records to acknowledge you received the paperwork. The other copies are for you. If you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. Ms. McClure and Mr. Deger-Margosian, thank you.
Thank you.
There's no jail order, right?
No, I deferred it.
Okay. No days deferred, just zero. You didn't say any days deferred, just zero.
I gave him 1 year jail deferred with 8 days credit.
Thanks.
I'm keeping really good notes too.
Okay. I missed that part.
All right.